Hello, viewers. Welcome to the another episode of Training and Learning India. Today we have a very good guest, and she is from a very renowned place, and her name is Professor Mahima Tripathi. Welcome, Professor Mahima. How are you?
Thank you, Tushar sir. I'm doing good.
ओके सो गाइज आज का जैसा कि हमने पहले बताया था हमारा टॉपिक है इंटेलेक्चुअल प्रॉपर्टी राइट्स। सो इंटेलेक्चुअल प्रॉपर्टी राइट्स कहीं ना कहीं एक बहुत बड़ा सवाल रहा है ड्यूरिंग सो लॉन्ग टाइम, एंड काफ़ी टाइम से हम लोग इस चीज़ को कवर करना चाहते थे, बट कहीं ना कहीं देर वर सम डिफिकल्टीज वी वर फेसिंग, वी वर नॉट गेट, वी आर हैविंग सम चैलेंजेस, और कहीं ना कहीं आज हमें हमारी प्रोफेसर महिमा त्रिपाठी एक बहुत ही अच्छी चीज़ और एक बहुत ही अच्छे तरीके से एक्सप्लेन करने वाली हैं। एंड लाइक महिमा जी, हाउ वाज योर जर्नी इन द फील्ड ऑफ लॉ? लॉ एक ऐसी चीज है, शायद लोग इसके बारे में बात करना एंड इसके बारे में सोचने से पहले 10 बार सोचते हैं।
बिल्कुल
और
बिल्कुल
for startups, like intellectual property is something which is very unknown and an alien thing for. So what would you like to say, like थोड़ा बहुत अपने लॉ जर्नी के बारे में बताइए, where are you from and what all things you did so far?
बिल्कुल Thank you so much, Tushar. Hello everyone. Good afternoon. And I'm Mahima Tripathi, as Tushar sir has introduced me. Presently, I am pursuing my PhD as a research scholar from IIT Kharagpur. In IIT Kharagpur, there is a department which basically deals with law. That is the Rajiv Gandhi School of Intellectual Property Rights. The name only suggests intellectual property rights. So all the basic norms in relation to intellectual property and thing are being dealt there. So presently I am doing my PhD from there. Prior to that, basically I am also from Bhopal. So I did my graduation, that is the BLLB honors from Department of Legal Studies and Research, Barkatullah University. You all must be aware of that prestigious university. Then after 5 years of BLLB, it was a really very nice journey. To be very frank, the most beautiful part or moment of my life was in that institute. As you know that colleges are awesome. So we have a very relatable memories from the colleges. After that, I pursued my LLM. 2 year, mine was the last 2 year LLM batch. So I pursued my LLM from National Law University, Bhopal. So at that time, my area of specialization was intellectual property rights and business laws. There I did my LLM and did my dissertation in trademarks only. After that, immediately after that, I went into litigation for 6 months. But after doing litigation and all, I was like, as my interest was into academics, then I just wanted to give a try for litigation. So I gave a try for it, thing for it. And after that, I started teaching. I came into teaching. So for 6 months, I taught in a university in Bhopal only. It was near to my house. That is why I picked that university. Then in 2016, January 2016, I joined Hidayatullah National Law University as the assistant lecturer there. So I worked there for 2.5 years at Hidayatullah National Law University. After that, I switched to Dehradun and I was here in a school of law, IMS Unison University, for 1 year. After that, doing teaching in I was when I was in teaching, so there was in back in my mind there was something that I had to do PhD. If you want to be in academics, PhD is something which you must do. So I was very much confused whether I should do PhD from any institution or from some renowned institution so that it will be helpful for me. So I thought that I should quit from my job and pursue regular PhD from a prestigious institution so that I can learn so many things, because as we all know that we are learner at each and every step. So I wanted to pursue my PhD from there. I joined there last year in July. So now I am doing my PhD and the things are going very smooth as my interest is in law. So obviously I will say that is a very good branch where you can learn not about the law but all the social aspects, because law, what is law? It is something which is relation to our society. So social things are being implied into it, and that is why I have a keen interest in law. And if you people are also interested, I must say that this is the very dynamic field if you want to pursue. There are a number of scopes for it. And I would also like to thank Training and Learning India to make me a part of their thing, because they are the one of the growing and prestigious platform, institutional link between the organizations. And through this platform only I can contact with number of students, I can help them, I can. And as we know that dissemination of knowledge is the thing which we all should continue. So thank you to Training and Learning India for providing me this platform. And also on the behalf of people who are other associated with you, I want to thank you on behalf of them also, because it's a very good initiative and very good platform which has been provided to all of us, to the teachers and to the learners, to the institutions, to everyone. Thank you. So
since it
as
has been a challenge since it has been a challenge like एक सीखने के लिए काफी चीजों पे डिपेंडेंसी थी आज तक, but now we
बिल्कुल,
have seen that this digital modem is actually helping us a lot to reach students and sitting back their home. They can, like, on every Sunday they're actually waiting for this webinars, like, which we conduct on Sundays. So
yeah.
like काफी अच्छी चीज हमने एक डोमेन को क्रिएट करने की कोशिश करी है, and in future we'll always try our best to keep this up. And so Mahima, I think we can begin with the presentation.
Yes, 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 yes. So today, my topic, which I will be discussing with you all, is the intellectual property rights. First of all, I would like to say that intellectual property rights in itself is a very vast topic. It's not something which we can discuss in one day and we can finish it off. So it's a very vast topic. That is why I will just give you an introductory basic knowledge about it, that what does intellectual property right means, what all things comes under it, and what are the scopes of intellectual property rights, why it has been introduced in today's world. So, Tushar sir, is my PPT visible to you all?
Yes, yes, your PPT is absolutely visible.
Okay, okay,
You may
okay.
continue. Over to you.
Okay. Thank you, sir. So, to start up with, I would like to say that today we are being connected through a digital medium, digital podium, and we are learning so many things. So, what do you think? This is also an example of intellectual property. This is the example of some technology which has been created and which has provided us a medium to learn, to gain knowledge, to expose ourselves in various fields. So technology is also example of intellectual property rights. Now, to start up with, the term intellectual property. First of all, we have it constituted of two words, in fact three words. That is the intellectual property and the rights. So first of all, we have to understand the concept of property. That what does property means? Then only we can relate it with the intellectual, and then only we can talk about the rights and the duties which are associated with them. To start with, the term property, as you all know, that what does property means? You can associate, a layman can associate it with the things which he buys, which he possesses, of which he is the owner. So it is, the term property can be used in number of senses. So it may include whether it is animate or inanimate things, which directly or indirectly belongs to the person. And also these this property have all the legal rights like a person, like liberty, life, reputation, estate. So property generally denotes the relationship between human beings and the things. This means that whatever property you have, it connotes a relationship between you and that very particular thing. So if you own a house, that property belongs to you. So there is a relationship between you and your house. So you and your thing. So it is a relationship between human being and the things which they possess, of which they are the owner. It is a legal, economic, and social institution. The dictionary meaning of property is that it is something that is owned by a person or business. Or in simple language, we can say that property connotes or means a bundle of rights. So if you have a property, so there are number of rights which are vested upon you in relation to that property. Suppose if you have a house, so there are number of rights which are associated with it. like you are the owner of that very particular house. You can rent it out, you can sell it out, you can mortgage your house. So there are number of things, all these things which I have told you, that selling, mortgaging, renting out, these are the rights which are being associated with that very particular property. So each and every property which you possess has number of rights which are associated with you also. And most significantly, you can relate it, or the most important attributes, rather we can say, are the ownership and the possession of the property. Now, anyone who owns that property, suppose you purchased a house, you bought a house, then you are the owner of that very particular property. And if you're staying there, you're living in that very particular house, then it is you have the possession also. Owner and possession are not totally same. An owner can have the possession, but possession, a person who has the possession, it is not always necessary that they are the owner of that very particular thing. This is something which has jurisprudential point of view, and we can discuss it later. Then also the owner has exclusive right to exclude from its property and right to alienate its property. Like I was giving you example of your house only, of which you were the owner. So right to exclude means that that property belongs solely to you. So you have complete authority or right to exclude other, to interfere into your rights, encroaching your territory or anything like that. So you have complete right to exclude others. Right to alienate, like I said, that right to alienate means right to sell it out, right to transfer, right to assign. So you have all the rights in relation to your property. Most important thing in relation to property is that these rights are right in rem. There are the right to exclusion is of right in rem, which means that this right is available against other people in general. There are two types of right, that is right in rem and right in personam. So right in rem is something in which is applicable against all the people. So anyone, irrespective of any contact or anything, if they encroach into your territory, then you can bring legal action against them, and therefore property has the exclusion of right in rem. Now, properties can be divided into number of things depending upon their legal interest, and by through law also they have been differentiated under number of categories. So as of now, I was giving you example of land, you have car, you have mobile, all these things, which these are the things which you can see. So they are being categorized under the heading tangible property. And another head is the intangible property. As the name suggests, intangible properties are those properties which cannot be seen, which cannot be touched, but they can be felt, they can be experienced, and they exist. So tangible property may again be divided into movable property and immovable property. So your house, your car is example of movable property, your whole house and everything is example of movable property. Whereas intangible property, as I said, that it is something which cannot be seen, but it can be felt, it exists. So goodwill, your reputation, the intellectual property are some of the examples of intellectual property. So here I have given the examples of tangible property, which includes the land, chattel, building, etc. Intangible property includes IP, reputation, goodwill, etc. So in order to explain it more elaborately, I can give you an example. Suppose if you have a book, you go to a shop and buy a book for you. The book is in form of tangible form. So it is a tangible property which you have the possession of it. Now you can touch that book, you can feel that book. So you have the possession of that very particular book, and you are the owner of that very particular copy. I'm talking about that you are the owner of that very particular copy which you have, not the content. So these all things can be seen. You can very easily give that book to your friend for few days to study. So you have right to give it, share it also. You can sell that book to someone else if you are done with it. Then that is also the right which you have in relation to that physical copy of that book. Now, what about the content which that book has? A book is being written by, suppose, any author. So who is the right holder or author or the owner of that very particular content? The author who has written the book is the writer or the owner of that very particular book. You cannot claim your authorship or your ownership over the content when you buy a book. You can only claim your right over that physical copy, not on the content. So the copyright in that book is the intangible right, which cannot be seen or touched by someone, but it exists with the author. So if a person buys a book, he does not owe the copyright over the book. It is the person who has written it and he owes the right over that book. And as I've told you that the house, chattels, and all these are the examples of tangible property. Now, I hope you can easily understand that property is a very wide notation which includes movable, tangible, and intangible, and we will be discussing in one of the category that comes in the intangible, that is the intellectual property rights. Now, as the name suggests, it's intellectual property rights. We have understood the concept of property. Now, intellectual means something that is being created by one's mind. Now, you cannot see it. You can have the idea of it. You can express it. You can uh, bring it out in the another form and any physical form, then only it can be sensed out. So intellectual property refers to the creation of mind, that is the invention, industrial design for article, literary and artistic works, symbols, etc. used in the commerce. And basically this intellectual properties are the source of commerce and used in the commercial activities. Now, intellectual property is a category of intangible rights protecting commercial value products of human intellect. Then it denotes the rights relating to one intellect's, one's creation of mind. So, one example can make you understand this thing more easily. Suppose A is a boy who went to the jungle and took a wood log along with him. Now, until unless that wood log is with that guy, it is in the form of something which is for everyone. Not a single person can claim authority over it. But what that boy did, that boy craved some sculpture over it, put some design, craved some images over at that very particular log by applying his intellect and his labor. Now, the boy who has applied that intellect over that sculpture, over that log by putting some images, sculpture, and everything, now that very particular thing, that very particular log belongs to the person who has created it, who has applied his intellect into it, who has invested his time into it. And what he did, he craved some drawings, some pictures into it by through his intellect only. So that property belongs to him, and that is an example. That can be an example of intangible property. Now, which was in very raw form initially, and over that he cannot claim his authorship or something like that because he brought it from the jungle. But the moment he craved anything upon it, he applied his mind upon it and created something creative, and created something out of it. Then where that very particular object belongs to him, and he is the owner of that very particular log, as he has applied his intellect as well as time upon it. So there are many similarities in the traditional properties as well as these intellectual properties. Like tangible properties can be sold out. Same is with the intellectual property rights also. You can easily sell it out. When someone is selling out, other person has right to buy it out. So it can be it can be bought, it can be leased or rented out, it can pass, and you can pass it under a will, or it can be assigned also for a particular time for particular task. Now, what is the nature of intellectual property? So basically, as it is the creation of in human mind, it's intangible property. It has there are various statutes which deals with intellectual property. So there are a number of intellectual properties, and for that we have the different legislations or statutes which purposely deals with them in order of their protection and promotion and registration. Then these IPRs, in short, we call intellectual property rights as IPRs. So these IPRs have the limitations and the exceptions also. So limitation is that they are not perpetual. It is time bound. So time limit is being given. Every author, every owner of that very particular invention or the creation has a limited time period. After that, it can be renewed also, but if the person does not want, it can come into the public domain for public. Time bound, territorial. So these are the few basic natures of IP. Now, as I was saying that IP, intellectual property, is a very wide term. It is divided into number of things. So basically, intellectual property can be subdivided into two categories. That is the industrial property and another is the copyright. So what does industrial property means? Industrial property means the properties which are used in the trade and for the trade and commerce purposes and which are being the object of monetary or which give the economic benefit to the person. So the patents, the trademark, the geographical indication, the trade secrets, all these things comes under the industrial property. Whereas the another category is the copyright and its related rights. So this is something which is the manifestation of one's own personality. So this very particular things is not always for the commercial purpose. Some people write books for their own interest, for their own because they have the creativity. So the two categories are the industrial property, which is associated with the commerce trade purposes, and copyright, which is a source of commerce and trade, but basically it's a feeling of someone who writes into it. So how these are protected? These various IPRs are protected by patented objects, the trademarks, the industrial designs, the trade secrets, layout designs, and the geographical indications. Now, intellectual property, what does it consist of? So it shall include rights relating to literary, artistic, and scientific work, performance of performing artist, phonograms, and broadcast. So this very particular head comes under the Copyright Act. Just initially I told that there are a number of categories associated with it. So one is copyright. So copyright is associated with literary, artistic, and scientific work, as well as the performance of performing artist, phonograms, and broadcast. So in second category, we have the patents, which talks about the protection and the registration and the promotion of inventions in all field of human endeavor and the scientific discoveries. Then we have the industrial design, and the trademark law protects the trademark, that is, and the service marks and commercial names and designations, protection against the unfair trade, and all other rights resulting from intellectual activity in the industrial, scientific, literary, or artistic work. So all the rights associated directly or indirectly or resulting from them are being protected under these heads. Like literary work के लिए we have the copyright, so उससे related जो भी rights होंगे they will be protected under the copyright. Invention से related जो भी technological advancement and everything will be protected under patents, and the marks related marks, logo, symbol वो trademark में and their rights associated with it will be protected under Trademarks Act. Now, as a law student, we know that behind each and every law, act, or any change, there are some theories, and there are group of people which favor that theory, and there are group of people who do not favor that theory. They criticize about it, and then only a proper and a good law come into the social in the society, so that people are benefited by it. So same was with the IPR also. So in relation to IPR, many of the jurists were in the favor of intellectual property rights, and they propounded few theories or few justification theories in relation to these IPRs, and they said that they caged this very particular theory and stated that okay, this very particular theory IPR relates or fulfills the criteria which the society needs, therefore they are justifiable. So some of the theories which are very important in today's context are is first of the utilitarian theory. You must have heard the name of a very renowned jurist, Jeremy Bentham. So this theory, particular theory, was being propounded by him. And utilitarian means that maximum benefit to the maximum people. So if, according to Jeremy Bentham, if an act is to be done, if something has to be done or something has to be introduced, it should be in such a form that most of the people around it or associated with it should be benefited. It's not like that case something is invented and no one is benefited by it and you can acclaim it. No. According to utilitarian theory, if a particular thing or IPR is being introduced, it must be sufficient enough to make most of the people happy because of it. So, in order to give its example, take an example of this fan. When fan or something cooler AC was being invented, what was the purpose? A person who invented it, that invention was in relation to that. Okay, this very particular thing, इसमें three वो wings लग जाएंगे, and when it is attached to electricity, वो generate होके and it will give air and हवा देगा सबको. So what is the purpose? Okay, this was the thing and which benefited a group of people. Now everyone can use that very particular invention and get benefited out of it. So according to Jeremy Bentham, any invention, any work, any intellectual property which is of helpful or which provide happiness or in today's language, in today's word we can say it convenience, which can give a better life to us, which can give a convenience in our which can give convenience in our way of living, that very particular thing is justified. And one of this was the utilitarian theory according to Jeremy Bentham. Another theory which was being propounded by John Locke was the labor theory. Now, labor theory ke through John Locke wanted to say कि if a person is putting up his intellect, is putting up his time, is putting up his labor into a particular work, then that very particular work should be acknowledged and should be incentivized. Otherwise, what will happen? The person will not be encouraged. So, in order to give encouragement and to recognize his labor, his intellect, his time, this theory was being propounded, and he says that whoever works, that work has to be acknowledged, should have be, if it is right and beneficial for everyone, should be appreciated, so that the doer or the person who is behind it should be benefited. And the major concern was him in relation to labor theory was that we all know about the physical labor. We have never thought about the mental labor. So whenever we ask a person to do some physical work, we acknowledge that work, we always appreciate and we pay for it. But what about the mental work which a person is putting into the thing? So he said that apart from physical labor, we have to understand that a person has through his intellect create something in IPR, and that mental labor should be acknowledged and also it should be promoted and renowned. Now, next theory was being given by Hegel, that is the personality theory. And he simply said that a work of a person is the manifestation of his personality. Therefore, it has to be acknowledged accordingly. And according to personality only, his or her personality only, the person invest into that very particular thing. So suppose when the authors write some books, and when you study into it, so kahin na kahin uska they have in that the very particular content, they have the manifestation of their personality, which cannot be separated from their work. So therefore, this very particular theory was being propounded by Hegel and said that कि कोई भी काम अगर intellectual property का भी होता है, then that very particular thing is being governed by the manifestation of one's personality, which is inseparable part of it. भले ही 0.5 ही personality का manifestation होगा, but it will be there. Now, coming to so these were the justification theories which were being propounded by various jurists of that time in relation to justify the intellectual property rights in that time. Now, what are the various types of IPRs? As I said initially, that patents hota hai for invention, for technological advancement. So, geographical indication is there, which talks about the goods and the association of people. You must have heard about the Nagpuri oranges, Kashmir ke save. So all these things are all these are the goods which are being associated to a particular territory and which are being through the टेरिटोरियल और द एटमॉस्फेयर की वजह से जो चीजें होती हैं लाइक सॉइल की वजह से देयर टेम्परेचर सो दे आर बीन famous for it. Next is the trademark, which is being given for 10 years, and it can be extended for again, it can be renewed again and again if the trademark owner wishes. Copyright has the limitation lifetime plus the 60 years after the death of the author. Now designs may we have the 10 plus 5 years perpetuation. Now coming to patents, I would like to tell you all that whenever we talk about intellectual property rights, though we are very new, this very particular term is very new. It was not like not it was not that much famous like conventional laws we have, but you cannot say that prior to these laws, these particular rights does not exist. It is not like that. From time immemorial, we have the rights. We have patents right, we have copyright act right, trademark, but they were not recognized because when we talk about different civilizations like Harappa civilization and all other things, uske time pe you can see that so many evidences are there which gives us the idea that how advanced they were, how intellectually they were advanced. So you cannot say, and that was because of their intellect only. So you cannot say that this is something जो 17th century or 18th century में आ गया and we are now studying it. It's not like that. Yes, the debate of their protection, debate of their registration has been initiated in few years back only, but you cannot say that does not prevail in our society because human beings, when we talk about human beings, you talk about mind. When you say they have mind, they have some intellect, they have some creativity, and they without any creativity, human existence is not possible. So same was case at that point of time. So patents are the exclusive rights which are granted by the government to a company or individual for an invention. Now, invention, what is invention? When someone comes up with a new technological advancement and that particular work has the novelty, is new, is capable of industrial application and have some value in the market, then that very particular invention is patented. That very particular thing comes under the head of patents. Various times it has been seen that people generally who does not have deep knowledge or who do not know much about the IPRs, they generally confused among themselves कि okay ये चीज है तो ये copyright होगा कि patent होगा कि trademark होगा. So it has to be understood very clearly that all the inventions, all the technological advancement which are in relation to the product as well as the process comes under the purview of patents. So a person who has come up with the new product, new process can patent their invention. Now, under the Patents Act 1970, there are number of criteria, number of provisions which has been provided, and few says that what inventions are patentable, what inventions are not patentable, what are the rights of patentee, what are the duties of patentee, how a patenter can register his patent so that uska jo patent hai it is not infringed or used by other people. He can enjoy his right, he can claim royalty over it. So all these things are being provided under the Patents Act 1970. This patent right is given for, as I told you, that IPRs are time bound. So this particular patents right is provided for 20 years from the date of filing of the patent application. So the procedure of filing of a patent application, it is a bit lengthy and time consuming process. So the moment you give your application for the patent, then from that day onwards, it is being counted, and till 20 years it is valid. After that it comes into the public domain, or you can go for its renewal. Next term is trademark, and most of you are being aware of this very particular thing. जब भी हम कोई गाड़ी देखते हैं, we associate it with the logo, we see their logos, their names, their marks, and we can very easily recognize, okay, ये कौन से brand का कौन सा गाड़ी है. So the main purpose of trademark is to differentiate the goods and services from one manufacturer or one producer to the other. So in a way, this very trademark act or trademark thing is for the manufacturer, producer, as well as for the consumer also, because through this marks, through their authenticity, we can understand and we can associate to a particular brand. Okay, this very particular good belong to this brand, this company, and we have that very particular company has goodwill, you have attachment, and you were been using that thing. So it's a kind of relation between, it creates a relation between the producer, the company who provides the goods and services, and the customers who avail those goods and services. So this Trademark Act was enacted in the year 1999 in Indian Trademark Act. And what does this things do? It is provides some logo, symbol, word, sound, design, and other device that is used to identify a business or a product in commerce. So initially in trademark also, it can be divided that initially what was there, we can the things which were associated with trademark were the logos, symbol, word, design, something like that. But with the advancement of technology and everything, commercial things are also developing day by day, and market people are tending to make their goods different from others. So what are the things which they can associate with that? So uske liye they have started putting up some unconventional or non-conventional marks or things with their product, like sound mark, color mark, smell mark. These are the things which are not the conventional trademark. They are termed as the unconventional or non-conventional trademark, which were not used earlier. So these are also the things through which you can understand. To give an example, Nokia phone, when you switch on the phone, it gives a different sound. So without without seeing that very particular mark, logo, or anything like that, you can easily understand or recognize just by hearing the sound of that very particular thing. This is a Nokia phone. So Yahoo Doodle and all are the examples of this. So this was done because as market was expanding, so only initially agar hum baat kare symbol, logo, word ki, so these were the things which can be seen through eyes, and the color, sound, smell are the things which can be felt through other sensory organs also. Like sound can be felt or heard by ear, smell marks here you can relate that very particular commodity or good, and you can smell by ear, nose. So this is the movement from conventional mark to unconventional, non-conventional mark, where we or the market people started exploring other sensory organs, use of other sensory organs in order to expand their market and circulate their thing. So in every product, whatever you buy, it's a trade and commerce wala thing, and it consists of trademarks. So the sign TM indicates the application file for products. service mark is there, registered trademark is there. So all these things are there, and Act of 1999 provides how it has to be filed, what comes under the category of trademarks, what are the rights of registered user, what are the rights of proprietor, and everything like that. And also these acts explain or provide that it is not only the marks which has to be protected, if the services also has to be protected, like Air India का अपना एक sign है, so वो trader commerce में है, you can associate it with it. So marks and goods and services are being associated with it. And also, if in case the infringement is there, how then, what amounts to infringement, how the remedy should be given, what penalty should be given, all these things are being incorporated in their respective legislations. Now next is Copyright Act. Copyright Act, as I told you, is something the creation of one's mind. So if you are writing something, so book, novel, technical reports, painting, photographs, music, movies, television, broadcast, computer software, database, are these, they all are the examples of copyright. Now copyright is very important thing because कहीं ना कहीं each and every one of us have the tendency to write some or the other stuff at some point of time, express their feeling at some point of time. So that is protectable under copyright. And Copyright Act specifically says it, we have the Copyright Act 1957 for it, and it specifically says that protection is given not to the idea but to the way of expression. Because if we start protecting the ideas, then what will happen, that other person cannot express it in a simple or in better way. So ideas are not protectable, but yes, the way of their expression is protectable under the Copyright Act. And also the registration of copyright is not at all compulsory or mandatory. It is very objective and it is very discretionary that whether a person wants to protect or register their copyright material or not. The moment you write something, your copyright vests over that very particular document. But just in order to give a validity, um, evidentiary value over that very particular thing, it is advisable to go for the registration of copyright. Now, when we talk about that copyright subsist in the not in ideas but in expression, so it is very true, because what will happen, if we keep on protecting the ideas, then there will be no scope for any modification, for the further modification and bringing of new ideas into it. So for this we have seen number of examples, like when a person makes some movies, like for example Bhagat Singh pe you can see number of movies were being made. So what was the difference? The character was same. उस character के जो description है, the events which he did, when he was born, what acts he did, how much he contributed, how much he struggled, what was his role in the independence, and who were the people associated with. These are the facts which remained the same. But every other time, the person who made that very particular movie expressed in very different form. So that is the beauty of this very particular Copyright Act, which does not protect the idea but the expression, and their way of expression will be protected. So we have seen number of things like um, love marriage, communal rights. These are the facts or the ideas. Now, in that facts and ideas, a person can express in any way, and it can be protected under this act. Now, as we are suffering from a big pandemic, coronavirus, and I'm damn sure that up when this very particular thing will be over, there will be number of series, episodes, movies, documentaries, which will be there in relation to this COVID-19, what were the sufferings of the people and all. So the object is same, the fact is same, that okay, ye coronavirus was there and how people were affected, but their way of expression will be different. So this it will be protected under the Copyrights Act. Now, why is it important to promote and protect the intellectual property? See, everything which we do has the two-way effect. So if this particular IPRs are beneficial only for the producers or the person who are making for it, then it is not justified. Or if it is only helpful for the people who are consuming it and not for the person who is making it, then also it is not justified. So it it has to be in balanced approach. So whatever promotion or whatever creation is to be done, it should be in such a manner that it should help people at large and should promote and encourage the person who is bringing that very particular thing also. So the progress and well-being of humanity test and its capacity to create and invent new works in the area of technology and culture. So if we are protecting one's right, it will encourage that very particular person ki, okay, now this right is being protected, promoted, acknowledged. Now I should work further on it, and I should work further for something else, so that I should be benefited by the recognition, by the reward and everything. Then the legal protection of new creation encourages the commitment of additional resources for further innovation. The promotion and protection of IPR spurs economic growth, creates new jobs in the industries, and enhances the quality and enjoyment of life. So somewhere these things are the thing. Just we can say that whatever the justification theories which we have studied and which are being propounded by various jurists, ये सारे चीजें उसमें you can see those things in the present context also. Now, IPRs generally exclude third party from exploiting the protected subject matter without authorization of the right holder. By giving legal protection to the inventions, to the work of the creator, what the law is doing, law is excluding others from unauthorized use of the person's work by providing him the remedies against the infringement or unauthorized use. By this way, they are helping the people in encouraging their work. This enables IPR owners or the right holders to use or disclose their intellectual property without fear or losing of control. What happens if you have some idea, if you have created something, the chances of getting it theft by anyone else is very, very common in nowadays. A single idea can be theft very easily. Therefore, in order to encourage and make the sense that okay, your work will be protected in the name of yours only, you will not lose your control over it, or no other person will claim their right over that very particular thing. We have these laws, and through this the owner get this security, and sense of security helps them to promote their work, encourage them to do more work. Now, role of IP as an intellectual property. It gives economic right to the creator. Now, creator के कैसे right generate होते हैं? सबसे पहले, apart from money, the most important thing which he gets is the recognition, reward through the society. And I think that is the most important thing which a person needs. Apart from that, what are the economic rights? How he can generate his economic rights? By licensing out his creation, by selling out his creation, by putting that very particular thing in the public domain. उसके बाद क्या होता है? When the thing is in public domain, the creator gets a specific amount of royalty, and through which he gains the name as well as the economic benefit. Then the commercial exploitation of owner of the IP, capital expenditure, transfer of technology, cultural development. These are the roles of intangible property as well as the tangible property. And through this, the person gets the recognition and his creation gets the award, and people at large can use it. Need of intellectual property, why we needed it. So as I said, in order to create a balancing approach, creator and user both rights should be protected. So strong IP rights help consumers make an educated choice about the safety, reliability and effectiveness of their purchases. Like when we talked about the Trademarks Act, you can associate and relate with the mark of a particular brand or company, and then you rely on into it. So it creates a connection between the producer and the user, in sense of safety, reliability, and all. Then the enforced IP rights ensure products and authenticity and of the high quality that consumers recognize and expect. IP rights foster the confidence and ease of mind that consumers demand and market rely on. Now, for the protection of IPs, all the countries have their legislations which talks about the protection and promotion of IP. Now, why it has to be protected? To give statutory expression to the moral and economic rights of the creator in their creation and rights of public in access to this creation. Second, to promote the creativity and to encourage fair trade, which would contribute to economic and social development. Now, in India, we have the Patents Act, Trademarks Act, Copyright Act, Geographical Indication Act, Designs Act, and a number of acts are there for the protection and promotion of intellectual property rights. But internationally, we can feel the presence from the year 1883. So in the year 1883, Paris Convention took place for the protection of industrial property. So these are the international covenants which cannot be neglected when we talked about the IPRs, because when we talked about their safety, their introduction and all, so obviously at international level only first they were introduced, and then these norms and were being incorporated in the national legislations of the countries also. So in 1883 we have the Paris Conventions for protection of industrial property. Here industrial property, as I told you earlier, that it consists of patents, trademark, GI and all. So this very particular thing was for those industrial property. It was not for the copyrights. For in the year 1886, Berne Convention for the protection of literary and artistic work was being introduced, which talked about the protection of copyrighted literary and artistic work. Now, Patent Cooperation Treaty of 1970 was there. This very particular treaty is very important because it helps in the advancement of it lays easier the application process of the patents in different jurisdictions. Last, we have the trade related aspects of Intellectual Property Agreement 1994. You must have heard the term TRIPS. So this is the most important legislation, this is the most important agreement or convention in relation to IPRs. Now, in today's context, when we talked about IPRs, these TRIPS provide the minimum standards for the protection of the IPRs, and all the member countries of this very particular agreement are bound to incorporate those minimum standards in their national legislations. If they do not do so, then some action has to be taken against them. So they can increase the standard of protection, but they cannot decrease the standard of protection as has been provided under the TRIPS. Then what happened? There was an institution named BIRPI, that is the United International Bureau for the Protection of Intellectual Property. So as I told you earlier, that we have the Paris Convention of 1883 and Berne Convention for Copyright 1886. So the secretariat of these two agreements, conventions collaborated and they formed BIRPI. So it was set up in the year 1893 to administer the Berne Convention for the protection of literary and artistic work and Paris Convention. So when the Secretariat of Paris Convention and Berne Convention merged, they took the form of BIRPI. And the BIRPI is the predecessor of World Intellectual Property Organization. So what we heard here, the term WIPO, we talked about WIPO. WIPO is the successor of BIRPI. Now, this is the overall view of IPRs in a very nutshell, in a very basic way. When we come into these legislations separately, they are ocean in their self only. So in order to make a basic understanding, this was the thing which I thought, okay, these are the things through which I can develop a basic understanding among you all in relation to IPRs. Now, when I'm talking so much about IPRs, there are various scopes which are there in relation to IPRs also. So any person, any student who is doing his or her specialization in IPR can pursue the following portfolios or profiles. They have the option for patent agent, management company, IPR branch of a firm, trademark attorney. So these are the few options which are available specifically to the person of IPR stream. And as we are seeing that with the digital thing and everything, all these things are in what we say developing day by day, and the need for these very particular people are needed a lot in the market and the industry, because we see that number of students, technical students, are coming with the technology or development of some inventions in one or the very frequently. So there, how it has to be patented, who is the person who can make their draft, make their claims very specifically, that is the job of patent attorney. Agent, trademark attorney helps a person when they want to register their mark. And we have number of IPR firms also which provide opportunity to the law students so that they can develop an idea in this very particular emerging dynamic. And here I stop. Thank you so much for the patience listening and giving me chance to share my views with you, all of you. Over to you, Tushar sir.
Thank you so much, Professor Mahima. And like it's been a really good defined and refined details of the IPR which we were so expecting. So like IPR के बारे में काफी ऐसी चीजें हैं जो आज मैंने खुद पहली बार नोटिस करी है, एंड इतनी डिटेल नॉलेज मैंने शायद ही आज तक किसी भी चैनल के वीडियोस में इस टाइप से नोटिस करी हैं. So it has been really great for you. Like thank you so much, and we are grateful that we have you. So there is a few question. Like one question arises, like, ma'am, what is the process and the patenting of a patent and cost associated? Because
So the
with that
process.
only the students and the person said that, ma'am, 3 years before I created a power energy project, but when I search and try to take patent, it charged around me 70K. So just few years back, I hereby in IIT Madras students make same projects.
Okay.
So कहीं
So
ना कहीं.
uh, we have the Patents Act 1970, which specifically says कि भाई, if anyone is coming with an invention, if that invention is new, is capable of industrial application, have some value in the has some technical advancement, then that very particular invention can be protected under the act. और जो बंदा है, जो पेटेंटी है, he will be benefited by all the rights, जो भी उसको privileges मिल रहे हैं, and it will be protected under the very particular thing. And talking about the process for the patents is very bit lengthy as compared to trademark and when we talk about copyright, because this is something which is very technical thing. So जहाँ पे आपका requirement है, it should be novel, it should be technologically advanced, it should be industrially applicable. So when we talk about technological advancement, what is the use, how advanced your product is from the others product? क्योंकि अगर आप बात करो solar energy और इन सब का, suppose a product is there, so already if that particular thing is in the market, how, what new you are bringing into it? The question arises. If there is nothing newness in your object, in your patent, then it is not patented. ठीक है? So first of all criteria is novelty वाला. अगर novelty is not fulfilled, then it will be your application will be dismissed at that very particular stage only. So if your criteria for novelty चलो fulfill हो गया है, then what technological advancement it is bringing out? Does it have any, as I said कि patents क्या है, capable of industrial application we have seen, sorry, industrial उसमें था. So what the industrial application it has in the market, does it have any use for the people when it comes to the public domain? So it has also to be looked upon. After that, it must be capable of industrial application. So until unless these three things are not fulfilled, the patent's application is not considered only. And when we talk about the registration, suppose your all these three criteria you have fulfilled in your very particular invention, then you have to submit an application along with the this specifications. Now, what does specification means? Specifications is a document in which you will write all your claims. Keep, okay, this is my invention. This invention is for this very particular thing. Now, in that invention, what are the things which you have assembled? What are the chemical compositions which you have made in, and how proportional you have made it? So all the technicalities, एक चीज you have to mention into it. So it's not necessary कि आप पहली बार application अगर दे रहे हैं तो उसी time पे you have to give this complete specification. You have the time to give the provisional specification, और उसके 12 महीने या 14 महीने बाद you have the time to give the complete specification, where आप एक तरह से कहते हो ना कि trade secret है आपका, वो कि वो document पढ़ के other person can easily understand and make the copy of it. So it's a sort of that only. You have to write everything into it. Then once you have filed the application with the provisional specification, your application and specification goes through a big process where examination and a tight scrutiny is being done by the examiner of the patent office. जहाँ पे एग्जामिनेशन होगा आपके प्रोडक्ट को लेके, मार्केट में क्या है क्या नहीं, उसके अलावा इट इज बीइंग पुट इन द ऑफिशियल advertisement also, so that any person, it is not possible for them to know each and everything about each and every invention or technology. So they will put into the public domain so that the people at large, or the or जो भी people who are going through it or on the same field can read it out and claim their objection if they have any. क्योंकि कई बार क्या होता है, we just makes or fix few minute changes in the product and we say that ये हमारा invention है, which is not appreciated under the Patents Act. So agar if anyone has the objection in relation to that very particular claim, they can come before the authority. Then वही जो litigation में होता है, they have the opportunity for counter claim and everything, and it's a very big process. So if you are ready to satisfy through only, not your through your arguments, basically through your claims only, you have to satisfy the authority, the other person, that your work is not mere mix and fix of the earlier work. It is something which is new, which have the inventive step, which is capable of industrial application. Then only it is being done. And coming to the costing of the cost of the patents, yeah, it goes high. And what happens now for this, government also supports for the inventions. There are a number of institutions, even the colleges or the universities, in order to promote their student, in order to get the fame, in order to come in the race of the technological development, they only sponsor their students for the development or creation of some invention. So if you have any kind of contact or collaboration with any institution, governmental institution or private institution also nowadays funds a lot. So you can talk to them and आपका budget कहीं ना कहीं थोड़ा तो कम होगा. But yeah, it's a expensive process.
ओके, सो लाइक मतलब ऑलमोस्ट 70,000 एक पेटेंट के लिए खर्च हो सकता है अगर कोई प्रॉपर चैनल के थ्रू जाए तो,
That
लाइक
I am not
सिंस यू
sure,
हैव
sorry.
मेंशन्ड. ओके, सो लाइक अच्छा, एक और क्वेश्चन इन्हीं ने पूछा है दैट इट्स पॉसिबल टू सेल प्रोजेक्ट टू एनी अदर कंट्री. मतलब ऐसे प्रोजेक्ट्स को पेटेंट करा के आप किसी और दूसरे देश में बेच सकते हैं?
बेच सकते हैं, बिकॉज दैट इज योर प्रॉपर्टी अल्टीमेटली. सो आप किसी को भी बेच सकते हैं, आप उसको ट्रांसफर कर सकते हैं फॉर टाइम बीइंग. तो उसके लिए द वे यू सेल योर प्रॉपर्टी, मूवेबल प्रॉपर्टी, टेंजिबल प्रॉपर्टी, सेम राइट्स प्रिवेल विद द इंटेंजिबल प्रॉपर्टी एज आई टोल्ड यू. So suppose a technology is being developed by Training and Learning India, suppose, and they have their relations with the other institutions also out of India. Now, in friendly terms or out of business, commercial, usme you can easily transfer that technology, that very particular technology, to the institution which is based in America on whatever basis you want, चाहे आप royalty पे या आप पूरा उन्हें सेल करना चाह रहे हैं on a big amount, या आप उनकी कंपनी में कुछ शेयर लेना चाह रहे हैं, तो उस बेसिस पे it can easily be sold out, but after selling out you cannot claim your authority over it. and
ओके,
they will be governed by their own law because IPRs are territorial. So आपके यहाँ जो law है protection का, that may be different from the USA or other countries. So that then will be dealt according to their laws. But yeah, you have the right to sell it out or transfer it out. आजकल हो भी रहा है because see, most of the developed countries are working upon so much into the inventions and technological advancement. When we come to the developing countries or least developed countries, we lack so many stuffs. We lack human power, we lack monetary things. So because jab tak you do not have the good command or good resources over these things, it is very difficult for a nation to develop something for its benefit, for its people benefit. So nowadays, people are exchanging their technology, diffusing their technology among themselves on certain terms and conditions, so that उनका चीज promote भी होगा, उनको economic benefit भी मिलेगा, and as utilitarian approach कहता है कि maximum लोग benefit होंगे, तो वो चीज भी fulfill हो रही है. So it's like that.
ओके। सो एक क्वेश्चन और था मेरे दिमाग में, मैं पूछना चाहूंगा, लाइक व्हाट इज बेसिक, लाइक देयर इज अ डिफरेंस बिटवीन पेटेंट एंड ट्रेडमार्क।
Yes.
सो मतलब व्हाट इज अ थिन लाइन डिफरेंस इन अ सिंगल लाइन यू वुड लाइक टू से, कि
Okay.
मतलब ये
There is
क्या
a
डिफरेंस
major difference
है?
between patents and trademark. Patents, जैसे कि बताया, it is creation of your intellect as well as the trademark भी आपका creation intellect का. But in patents, technological advancement, if you are inventing something, if you are bringing something new, it's not discovery कि कुछ already exist कर रहा है and you are the first one to take it out and you can say ये मेरा patent है. No, discovery, there is a difference between invention and discovery, so you have to understand the difference. So अगर आप कोई भी चीज को invent कर रहे हैं, खोज कर रहे हैं, आविष्कार कर रहे हैं, सॉरी, खोज इज डिस्कवरी, सो वो आविष्कार विल कम अंडर दी पेटेंट्स एक्ट बिकॉज उसमें टेक्नोलॉजी भी लगा है, साइंस है, टेक्नोलॉजी है, लीगल प्रोटेक्शन है. सो दिस इज अंडर द पेटेंट्स एक्ट. जहां हम मेडिसिन की बात करते हैं, हम लैपटॉप की बात करें, अगर मोटर व्हीकल्स, आपका सोलर पैनल, ई व्हीकल, these are the things जो कि टेक्नोलॉजी से डेवलप हो रहा है ऑब्वियसली. सो these are the technological development invention and they are protected under the patents act. Okay, now coming to the trademark is something which creates a relation between the customer and the producer. सो आप सड़क चलते गाड़ी देखते हैं, BMW जा रही है, तो वो साइन लोगो देख के ही यू कैन इजीली रिकॉग्नाइज, ओके, दिस इज दी दैट वेरी पर्टिकुलर थिंग. सो आप क्या करते हो कि यू डू नॉट नीड नॉट टू ऑलवेज सी कि BMW कहाँ लिखा है, कैसे लिखा है, थ्रू दैट लोगो यू कैन रिकॉग्नाइज दैट थिंग. एडिडास का आप शर्ट पहनते हो, जूते पहनते हो, तो उसके साइन से यू कैन इजीली अंडरस्टैंड, ओके, दिस इज द पर्टिकुलर प्रोडक्ट विच बिलोंग्स टू दैट पर्टिकुलर मैन्युफैक्चरर, है ना. तो उस चीज का दैट ट्रेडमार्क बेसिकली एसोसिएट्स with the goods and the services which a manufacturer or a company is providing to the customers. It
ओके,
can be in any form. आजकल पानी की बोतल आ रही है, उसमें अपना बिस्लरी का अलग से ट्रेडमार्क है. ईयरफोन है, आप MI का एक अलग अपना ब्रांड बन चुका है, एप्पल का अपना एक ब्रांड बन चुका है. सो थ्रू दैट साइन ओनली यू कैन understand na ki this is the thing. So this is a way to demarcate the service providers basically, कि people should not get confused कि ये इसका है कि किसका है भाई मार्केट में.
या
So
अच्छा,
that is the
एक
thing.
एक ग्रेट, एक और क्वेश्चन था मेरे दिमाग में, लाइक एक कॉपीराइट होता है, सिमिलरली कोई एक कॉपी लेफ्ट टाइप का भी कुछ होता है.
I
सो
don't have idea. Left, but copyright is something when you write, it is basically granted to literary, artistic, dramatic,
ओके,
cinematographic, all these kinds of work are being protected under the copyright act. So अगर आप कोई पोएम लिख रहे हैं, अभी आपका बोलते बोलते कुछ थॉट आया, आपने पेन डाउन कर लिया, दैट इज योर कॉपीराइटेड वर्क, दैट इज योर वर्क, भले ही आप इसको रजिस्टर कराएं चाहे ना कराएं.
ओके,
तो
तो इसका
दैट इज
कोई
समथिंग.
सिंबल या कुछ इस टाइप से यूज होता है अपने प्रोडक्ट्स के ऊपर,
इसका ऐसे
कॉपीराइट का?
जरूरी सी a thing, an object can contain number of IPRs. सपोज आपने इन्वेंट किया एक माउस, ठीक है. सो उसमें जो टेक्नोलॉजी लगी, जो इन्वेंशन आपने किया 2-5 करके चीज़ों को असेंबल करके और जो सारी चीज़ें की, दैट विल कम अंडर द पेटेंट्स एक्ट। कॉपीराइट में आप उसे प्रोटेक्ट करोगे, ठीक है। अब आपको अपना प्रोडक्ट बेचना है मार्केट में, तो मार्केट में बेचने के लिए उसको थोड़ा-सा आप थोड़ा डिस्टिंग्विश करोगे, कुछ अलग बनाओगे, चाहे तो उसपे एक कलर लगा दोगे व्हिच विल डिस्टिंग्विश फ्रॉम अदर माउसेस जो बेच रहे हैं या जो भी है, या फिर यू विल पुट सम मार्क इनटू इट कि एक टीएनएल का जैसा आपका लोगो है, दैट लोगो व्हाट डज इट डू? इट डिफरेंशिएट योर प्लेटफॉर्म, योर ऑर्गेनाइजेशन फ्रॉम अदर्स। तो आपने वो लगा दिया, सो यू कैन रजिस्टर इट ऑल्सो। अब यही माउस को इफ यू आर गिविंग सम एस्थेटिक क्रिएशन, ऑर्नामेंटल क्रिएशन आउटसाइड उसका अपीयरेंस में, तो वो आप प्रोटेक्ट कर दोगे उसे डिजाइन एक्ट में। सो देयर आर नंबर ऑफ थिंग्स विच a single invention or single creation of IPR can have a number of IPRs with it. So this is the thing. और copyright में it's आपका expression protect हो रहा है, आपका नाम से जा रहा है वो। So ऐसे logo symbol नहीं होता है, but हाँ, people generally do write their books and जो भी है, it is protected. Like आप अपने research work में ही, when research is something you are researching on something, researching जो है उसी को रिसर्च कर रहे हो इन योर ओन व्यू, ओन मैनर। So while doing research and writing papers and also we refer number of people's work, ठीक है ना? In order to get ideas, we read number of content available on their very particular topic. So जब हम उसको पढ़ते हैं तो it's not like कि आप उसे कोट नहीं करते हो। अगर मान लीजिए आपसे मैंने कुछ सुना, आपकी बुक से कुछ पढ़ा एंड आई विल कोट इट इनटू माय बुक, देन व्हाट इज द बेस्ट वे? आई विल एक्नॉलेज योर वर्क थ्रू फुटनोटिंग वगैरह में जो होता है कि ओके दिस वेरी पर्टिकुलर स्टेटमेंट वाज said by Mr. Tushar in his book, ये वो करके। So in a way I am acknowledging your work also and putting your work in my thing also.
ओके
So इससे एक बंदा infringement और उससे बच सकता है acknowledgement से।
ओके, मतलब काफी डिटेल्ड चीजें होती
They
हैं
are very
इसमें।
technical, yes.
दे
वही तो
आर
अगर
वेरी डैम टेक्निकल।
overview is very thing, something which is very easy कि हाँ भैया समझ लिया ये है। When you go into their depth कि पेटेंट्स क्या है, क्यों है, कब मिलेगा, कैसे मिलेगा, पेटेंट ड्राफ्ट कैसे होगा, उसका सर्च कैसे होगा, how it has to be provided, what amounts to infringement, what does not amounts to infringement, they are very, वही कहा ना कि एक बहुत विशाल सागर है ये अपने आप में सारे पेटेंट्स, कॉपीराइट, ट्रेडमार्क एंड ऑल।
ग्रेट। So here we come to an end and like thank you so much, like
थैंक यू।
आपने इतना precious time दिया, अपना संडे आपने हमारे साथ स्पेंड किया एंड वी होप लाइक प्रोफेसर महिमा आगे भी हमारे साथ ऐसे सेशंस में जुड़ी रहेंगी। And guys, thank you so much for joining today's webinar. Thank you, Professor Mahima. And
थैंक यू
like
सो मच तुषार।
hopefully, hopefully we are actually expecting something good from your side. And like in near future, we are expecting some good courses. And in fact, other than courses also, like we are planning to have some good patents of some projects by several universities, so we can connect some good universities along with our like experts. So thank you so much. Thank you so much
थैंक
for
यू सर।
your participation.
Thank you for making me part of TNL, and I would be more than happy to contribute whatever knowledge, whatever in whatever way I can help you all. Thank you so much.
Thank you. तो गाइज इसी के साथ आपने देखा कि काफी सारी चीजों में हमने आज एक बहुत डिटेल्ड डिस्कशंस किए हैं कॉपीराइट, पेटेंट एंड ट्रेडमार्क्स को लेके। एंड वी आर एक्सपेक्टिंग समथिंग लाइक इन नियर फ्यूचर ऐसा भी हो सकता है कि आप बहुत इनोवेटिव चीजों को लेके लाइक आगे जब भी सोचें तो आप ये सोचें कि शायद ये पहली बार है और उस चीज को आप खुद कॉपीराइट करें, आप उस चीज के लिए ट्रेडमार्क करें, पेटेंट करें। तो इन्हीं चीजों के साथ गाइज देयर इज अ नंबर फ्लैशिंग इन द स्क्रीन। आप उस नंबर पे व्हाट्सएप और कॉल कर सकते हैं अपनी क्वेरीज के साथ, so we can connect you with our subject expert. And like we are having some certification courses also in intellectual property right, along with the help of LNCT University. So if at all you wish to join us, you can connect with the LNCT University And other than this, we have a UG program of BBA Business Intelligence and Analytics, जिसमें अभी एडमिशन्स चालू हैं. तो गाइज उसकी क्वेरीज के लिए भी आप हमें ज्वाइन कर सकते हैं, आप हमें कॉल कर सकते हैं इसी नंबर पे. थैंक यू सो मच फॉर ज्वाइनिंग टुडेज सेशन एंड adios.